Hello class, I'm Eddie from Athens, and I'm a juror on this case. The case where Jennifer versus AU Hospital. Jennifer claims that AU Hospital disclosed her protective health information for local judicial proceedings without informing her or making a reasonable effort to inform her and obtaining a protective order from the court. The defendant, AU Hospital, argues that a subpoena is a legal document and failure to comply could lead to contempt of court and legal actions against the hospital. The defense also argues that the patient signed a medical records release form that allows the institution to give her information to necessary entities. Also, the defense states there were efforts to contact Jennifer prior to releasing the information. The plaintiff argues that AU Hospital can show no evidence that they made a reasonable effort to contact her before giving her protected health information to the courts. She also states that she did sign the medical record release form, but it only stated that her information could be shared with insurance companies and other healthcare workers involved in her case. She states that it did not mention giving her information away for legal issues. According to the U.S. Department of Health and Human Services, a covered healthcare provider or health plan may disclose protected health information required by a court order to include the order of an administrative tribunal. However, the provider or plan may only disclose the information specifically described in the order. A subpoena issued by someone other than a judge, such as a court clerk or an attorney in a case, is different from a court order. A covered provider or plan may disclose information to a party issuing a subpoena only if notification requirements of the privacy rule are met. Before the covered entity may respond to the subpoena, the rule requires that it receive evidence that reasonable efforts were made to either A, notify the person who is subject of the information about the request so that that person has a chance to object the disclosure, or B, to select a qualified protective order for the information from the court. My decision regarding this case would be that AU Hospital did not make an adequate effort to contact Jennifer, and they did not seek a qualified protective order for the information from the court. Therefore, AU Hospital is guilty of violating Jennifer's rights and unlawfully disclosing her protective health information. Thank you.